Hi, good afternoon. Welcome to Preserving Needs-Based and Government Benefits. I am Stacy Scripp, and I'm with Capital First Trust Company, but I'm also a board member of the SSP. I will introduce our speakers in a moment. We are having some technical difficulties with one of our speakers, so hopefully he'll be able to join us soon. So if you see me doing stuff off in the background, that's what I'm doing. So while we're waiting, or while we continue wait, we'll get started. Today, I'd like to introduce our speakers. They're all very well known in the settlement planning world, in the trust and elder law world, and I have depended on all of them for many of my benefits questions. First, I'd like to introduce David Banis. He is his chief area of focus is elder law, in particular, helping clients plan for long-term care issues, assisting with the Medicaid process, creating and administering trusts and estates, and general estate planning. David also provides skilled special needs planning, helping families care for their loved ones by establishing guardianships, trusts, and other legal mechanisms to assure their stable future. Thank you, David. Welcome. Next is Shannon Lehman Pecoraro. She is a certified elder law attorney at Hook Law Center, where she practices in all areas of elder law. A large portion of her practice is devoted to assisting personal injury attorneys and settlement planners throughout the country, and to help develop asset protection strategies for their clients. Shannon graduated cum laude from the University of Baltimore School of Law with a concentration in business law. Shannon served as the chair of the Education Committee for the Elder Law section of the Virginia Bar Association and is active in public policy advocacy as it relates to elder law and special needs issues with both the Virginia Bar Association and the Virginia Academy of Elder Law Attorneys. Shannon is a member of various professional organizations, including the Special Needs Alliance, and a contributing author of the Special Needs Trust Handbook published by Wolters Kluwer. I hope I said that right, Kluwer. And then Julian Gray, who we are waiting, is the founder and managing attorney of Julian Gray Associates located in Pittsburgh, Pennsylvania, and has provided assistance to a variety of clients and their families for over 25 years in the areas of elder law and special needs planning. He received his bachelor's degree from Penn State University and his law degree from Duquesne University of Law. Julian is a frequent author and lecturer for continuing legal education programs and serves on various regional and national boards and committees dedicated to assisting individuals with disability. Mr. Gray is recognized as a multi-year Pennsylvania super lawyer and in Best Lawyers in America in the area of elder law. For over a decade, Julian has co-authored a monthly elder law column in the Pittsburgh Post-Gazette. So with that being said, I'm going to turn over our first section with David Banis, and he will be discussing an overview of some of our common public benefits. Thank you, David.
Thank you, Stacy. So it's again my pleasure to be here and talk about I think some basic concepts about special needs area of law, Medicaid, public benefits, and we really want to start with why all attorneys should care about this. Stacy, are you going to advance the slides, or how do I do that? Sorry. There we go. I just want to make sure, so I'll give you a thumbs up when we go to the next one. These three cases here they're not the most exciting things to read, but if you're having trouble sleeping, you might want to download them on your iPad. It might cause a little bit of anxiety. The first one is a case where the personal injury attorneys accepted a cash settlement that was far lower than what the actual case value was, according to the life care experts and things like that. And in accepting such a low cash offer, they sort of ignored previous offers that would have been structured in such a manner that would have provided much more money over the course of many years. and afforded the ability for the individual beneficiary to take advantage of governmental programs like Medicaid waivers and things like that. So the takeaway from this case is that you have to at least have a minimal understanding of what's out there in terms of public benefits to pay for medical care, particularly if there's a lot of care that's going to be needed. Bottom line is know enough to know when you need to ask questions of people that really understand. The second case really stands for a basic concept that if you're a fiduciary, you have a duty to know about these public benefits. If you take some sort of action that eliminates your, your ward or the beneficiary of a trust, if you're a fiduciary, you're looking out for people, you need to know not just what they need, but what they may be entitled to. And so again, as we get into understanding some of these concepts about SSI and Medicaid and the waivers and things like that, it's important to know. And again, maybe not to know every nook and cranny of it. That's sort of our job, me, Shannon, and Julian here. But to know when you need to pick up the phone and call somebody to talk through some things. The last case on here, this Maine Supreme Court case, or the Board of Overseers, basically stands for the proposition that you can commit malpractice if you're not doing something like including an S&T for a disabled beneficiary in a will. If you have the knowledge that the individual is eligible for Medicaid, if they would benefit from an S&T, and you don't know enough that you need to put an S&T or Medicaid payback trust or whatever the case may be for the circumstances in a will, you could actually be committing malpractice towards your client who you're drafting a will for. So again, just knowing at least where to answer or ask for questions and get some answers is really important. And that's why we should all be interested in, I think, what we're having to say today. So, next slide. Okay, so what are we talking about? The basics of public benefits and what public benefits. There are really two categories of public benefits that we concern ourselves with. What we think are the most important are those that are based on some sort of financial need. Those are the needs-based benefits. SSI is one of the most important, one of the most, I think, ubiquitous, also one of the most confusing of the needs-based public benefits. So supplemental security income, or SSI, is based on an individual that is disabled and that doesn't really have a work history of their own. So it's essentially an income stipend for food and for shelter costs for an individual that doesn't have support from anywhere else. We'll talk about that in the next slide or so. And then, of course, Medicaid. Medicaid, the insurance payer, health insurance payer of last resort. Medicaid can be obtained with a variety of other primary and secondary insurances, like private insurance, Medicare. Medicaid is quite often there again as the payer of last resort, but for many, many people, they can be dual eligible. So don't think, oh, well, this person's eligible for Medicare, so there's no need for Medicaid. That's just not the case. One of the things about Medicaid itself is it pays for things that Medicare doesn't pay for. The biggest one that comes to my mind that I talk about just about every day is nursing home care. Medicare pays for rehab, for you to go to a rehab facility with the intention that you're going to eventually come home. But once that stops being rehab and you stop improving, Medicare doesn't pay for that nursing home bill or that assisted living bill or the in-home care, and that's where Medicaid comes in. And again, Medicaid being a needs-based benefits. There are veterans pensions benefits that are, again, needs-based, and more of these veterans benefits are looking an awful lot like Medicaid in terms of eligibility requirements. Some of the, the fringier ones, I guess, are food stamps, utility assistance, and housing subsidies. Those are often very, very important. The waiver services for those who have developmental disabilities or those that can remain in the community but require some long-term care assistance with activities of daily living. That's a Medicaid type of benefit. And then you go over to the non-financially based benefits. And these are your classic sort of entitlements that I talk about them as the entitlements. Social Security. You paid into the Social Security system, you retire, you get your Social Security benefit. Social Security Disability, or SSDI. How I describe this is it's early retirement for an individual based on their disability. You're still tapping your Social Security retirement account, but you're doing so early based on disability. Along with that comes Medicare, either when you're 65 or if you are receiving SSDI. And then other benefits like special education benefits. Again, those are entitlements under federal law. Survivor benefit plans from Social Security. So those are the ones that you're not necessarily worried about how much is in your bank account, how many assets you have, or really what your unearned income is. You do need to be somewhat concerned about your ability to work for SSDIs. So go on to the next slide. Okay, so a little bit of detail about SSI. Again, SSI is an income stipend for an individual who is disabled, but doesn't have their own work history to tap into, or the work history of a parent. And the maximum amount that you can get for SSI in 2021 is $794. That amount can be reduced if you're receiving income from another source. Earned income, unearned income, you're staying in mom and dad's house or a friend's house and you're not paying rent. All of those things go into how much that $794 benefit may be reduced. Okay. SSI, again, it's means tested. That means you can't have more than $2,000 in your bank account or any accessible funds of more than $2,000 in assets. Otherwise, you won't qualify for that. An important aspect of SSI is you have to show that you're disabled. And how do you show you're disabled? By something called substantial gainful activity. If you can't engage in work to earn income in this year, and you can't earn $1,310 of gross earned income per month, then Social Security will say that you're disabled. Because of your disability, you're unable to earn that amount per month. And so you're under that substantial gainful activity amount, and you can qualify for SSI or Social Security disability if the circumstance. So we'll go to the next slide and talk about how SSI can be reduced. And this is really, really important, especially when you're talking about, maybe there's going to be money going into a special needs trust. Is the special needs trust going to pay for an individual's rent or things like that? You got to be very aware if an individual is receiving SSI, how their SSI benefit could be reduced. The first one is this concept of in-kind support and maintenance. And the thing that comes to my mind is you're living rent-free in someone else's home. If you're not using the SSI benefit to pay for food or to pay for your own shelter, if you're getting it from somebody else, then they can reduce your SSI benefit by 1/3. So that $794 would come down by 1/3. For unearned income, income that is derived not from wages from working, there's typically a dollar for dollar reduction, and this might come into play when there are annuities involved, so be aware of that. For earned income, it's a 50 cents on the dollar reduction, so you get a little bit of credit for working. You'll lose the entire SSI benefit of $794 a month if your assets available to you are above $2,000 in any given month. That's a complete loss of that benefit. Or if your gross earnings from wages is in excess of that substantial gainful activity amount of $1,310 for disabled non-blind individuals. On the next slide, we will go over some of the things that don't count in that $2,000 asset threshold. SSI considers only certain things to be countable resources. Basically, if you can convert something to cash to pay for your food or your shelter, Social Security is going to deem that as a countable asset or a countable resource that's going to contribute to that $2,000 amount that you're allowed to keep. If you have, I don't know, you get $3,500 in 1 month, and let's say it's February, and by March the 1st, your bank account is not spent down below that $2,000 threshold, you'll lose your benefits for March, right? And it's always on a monthly basis as you turn over to the 1st of the month. You want to make sure that your bank account reads less than $2,000. But not everything that you own counts against that $2,000 threshold. So an individual is allowed to own and live in their own home. Okay, all the stuff that's inside the home doesn't count. TVs, furniture, tangible personal property, anything in the house just doesn't count for this resource requirement. An individual is allowed to have a car that's exempt. They can have prepaid burial and funeral contracts, certain life insurance policies, as long as you can't cash it in for more than $2,000. And then we have these new ABLE accounts. In Ohio, they're called stable accounts. These stable accounts are available nationwide. Great new tools for an individual, particularly those individuals on SSI, to have money and put it in a safe space, a safe place that's not going to be counted towards that $2,000 monthly benefit. Okay. Again, the non-means tested benefits. On the other side, this brings me to the point that when we're meeting with new clients, when I'm meeting with new clients, one of the most important things that I want to do at the outset, and oftentimes when I'm working with other PI attorneys and they come to me, the first thing we'll do is we're going to verify what benefit and benefits the individuals have. Because somebody says, well, this person has X number of dollars a month in Social Security. I want to know exactly what that means. Is it SSI? Because if it's SSI, we got a ton of things that we need to consider. Is it Social Security disability or retirement? We still need to consider a lot of things, but we don't need to worry as much about the means tested aspect. So the Social Security benefits that are not means tested are typical retirement benefits, where you have to have paid into the system for the requisite amount of time, and everybody's pretty familiar with that. Those really can't be interrupted. You're entitled to that because you paid into the system as long as you meet the age and work requirements. Social Security disability insurance, again, it has the work requirement. The work credits are, they vary by how old you are. But again, keep in mind, for Social Security disability insurance, that's early retirement based on disability. So the individual has to show that they were disabled by not being able to meet that substantial gainful activity. Dependent benefits are those that are from benefits for a spouse and children based on a retiree or disability record. If the child, this is very important in my mind, again, a minor detail that has huge impacts over the course of an individual's lifetime. If a child is disabled prior to the age of 22, and they're just eligible for SSI, when their parent retires and receives their Social Security, that SSI converts to Social Security disability insurance, and that individual can receive half of what the parent receives. And when the parent dies, it goes up to 3/4. And that's SSDI, not means tested. And when that also comes, so does Medicare a couple of years down the road. So 22 is a big age. If an individual is disabled, have we established that that disability has occurred prior to the age of 22? And then I got a couple more slides, and then I'll hand it over to Julian. For Medicaid, there's two types of Medicaid now. There's what I would consider to be the traditional needs-based, disability-based Medicaid. Medicaid for the aged, the blind, and the disabled. Think of individuals that go in nursing homes, people with disabilities that still fall under the resource requirement and the income requirement. That looks an awful lot like SSI eligibility. Then there are, and underneath that umbrella of that disability Medicaid, the ABD Medicaid, are the various waiver programs. If you qualify for Medicaid, you can get these waiver programs. And a waiver program might be additional services for a child with developmental disabilities. It might be aides that come in to the home and provide long-term care services for an individual a few hours a day for 5 days a week instead of that individual going into a nursing home. There are multiple types of waivers in Ohio, and I know in every other state for that matter, but they're all hinged on Medicaid eligibility. After the Affordable Care Act passed, we have Medicaid expansion. And Medicaid expansion is not disability based, it's only based on your income, okay? So it really doesn't matter how much money you have in the bank. You can be over the $2,000, but if your income, your adjusted gross income is below the federal poverty level, 138% of the federal poverty level, then you automatically get your Medicaid coverage in these managed care plans. And the idea is if you're over, and we'll go to the last or the next slide, the income eligibility for Medicaid expansion. If you're a single individual and you earn less than $17,609 in adjusted gross income, you get expanded Medicaid. You'll be on Medicaid. And if you're over that as a single individual, then your options are, you have to go on the exchange. That's the idea anyway. You go on the exchange and you purchase your own health insurance. But if your individuals fall in this under the yearly or the monthly allowances for family size, then they get this expanded Medicaid, and it's not based on disability, really only based on income. This can be a stopgap measure a lot of times for individuals that maybe aren't qualified for Medicare yet, but they're receiving Social Security disability income. They're sort of over in many respects all the eligibility requirements for SSI and traditional Medicaid, but they could fall into this until Medicare kicks in. Lots going on in these first 8 slides, I know, and I could probably talk for another 40 minutes on just this stuff alone, but we got to move on, so I'll pass it over to Julian.
Okay, thanks, David. Can you hear me okay? I know I had a little problem getting on there at the beginning, so I apologize. I had to set my browser apparently correctly to get on the program. So thanks for having me, and it's a pleasure to be able to speak with everyone. And so by way of background, I practice out of Pittsburgh, Pennsylvania, so I may have some things to say that are Pennsylvania specific, but we'll start off with first slide here on veterans benefits. Really an important part of any comprehensive plan in that we have such great volumes of veterans across this country. For example, where I practice in Pennsylvania, we're in the top 5 states in the country with veterans, and especially veterans over the age of 65. And so we're always being aware that we could have a veterans benefit issue. And as far as some of the things Dave was talking about with means testing on other benefits, up until a couple of years ago, it really didn't matter so much on veterans benefits for aid and attendance, which I'll talk about in a minute. But they passed a rule in October of 2018 that created a 3-year look back for gifts and a lot of things that we deal with in the Medicaid function. So now it's a lot more like the other means tested benefits. So on the slide here, we talk a little bit about pension and compensation, and just to the first review of this, it wouldn't appear this way. So let me just say this. Here's the way I categorize veterans benefits. I put it in 3 chunks. One is service-connected disability, the other is non-service-connected disability, and the other is healthcare. That's just the way I break it up into 3 big chunks. It makes it manageable for me. The VA system is crazy, and it's a federal benefit. You can apply anywhere in the country. So if I have someone in Pittsburgh, I can file my application in Minnesota if I want to. It really doesn't make a difference, which would be much, much different if you were applying for Medicaid, for example. But veterans benefits are really important because you can layer them within all these other benefits that David was already talking about. And so really the one on the slide that has the most information is the pension. We've many times called this aid and attendance. And so some of the things you see on here on the slide are things that have been put in pursuant to the new rules regarding like net worth at 130,000 and change. That goes up every December, and the 3-year look back for gifts now. So these are all things you really have to be aware of. So it's really important whether you're just checking in with that client for the first time to find out if they are a veteran, maybe they are the spouse of a veteran. Those are really important questions to ask. And most importantly, I tell people to get your discharge papers, which are a form DD-214, D as in David. And that's going to tell you whether that person was wartime or not. And so the first bullet point that Shannon, and by the way, thanks for doing the slides, great job. But the first bullet point that Shannon has in here, service requirement, right? There's a huge window. A lot of people think that World War II, ended when there were nuclear bombs dropped, but that's not really when that time period closed. It was much later. Many people don't realize there's a whole new wave of younger veterans coming up that may be entitled to benefits as they become disabled. So, we're always dividing this up into two kind of spheres of, were you disabled because you were disabled while you were in the military, or were you disabled because you're a veteran who later in life got injured or disabled or something? So that's really where you have to draw the line as to whether you're going for service-connected disability, which is at the bottom of the slide, or whether you're going to non-service connected disability, which everyone refers to as improved pension with aid and attendance. And so really, it's a huge, huge thing. You need to be aware of it. And the last thing I'll say about this slide is, one, big changes that happened in October 2018. I think around the country, people who practice in the area of veterans benefits are still seeing some trends emerging. And I will also say that if you're dealing with a veteran and they have a home, you really need to be aware of that the home is really one of the only pockets where you can make transfers of significant assets under the VA rules. And the transfer of the home is not subject to a penalty like Medicaid transfer penalties are for homes. So just something to be aware of. And there's a whole lot to do about veterans benefits, and we could talk about more during the Q&A. So let's move on to the next slide, please. And just as an asterisk, kind of, highlighting what David said earlier, we're paying attention to all these other, what I would call minor benefits, right? If we have a client that's getting a multi-million-dollar settlement and they're in Section 8 housing, and I know I've had those cases, and I'm sure others have, we're probably not worried about Section 8 housing anymore. We're probably going to buy them or build a very nice adaptive housing situation. So we just have to kind of check off the list here. I've had clients before who've given up food stamps because it was just a better thing on the other side of the planning that was going to help them. Or clients who've given away money and said, I'm going to go off of SSI for 3 years, and I don't care about losing $20-some thousand. It just doesn't make any sense to me to stay on SSI. So we're always looking at these things. And once again, it's just more of a, a check down to make sure you don't, first of all, disappoint your client, because you'd be amazed. Your client gets a net $500,000 settlement, and then they lose their food stamps, and they say, you didn't tell me I was going to lose my food stamps. And I'm like, well, what did you think you were going to do? So just, it's all about communication, right? And talking with your client and managing your expectations when they receive their settlement. I think that's probably enough on that slide. Okay, QSFs. Wow, this could be a whole seminar. So lots of QSFs. Okay, so not to get too technical, but Internal Revenue Code 468B as in boy authorizes the use of qualified settlement funds. And so as you'll see on the slide, the tax law permits payments to the QSF to discharge the defense carrier. Typically, there's some insurance carrier that's paying out. And so we don't really have our, one iteration of the QSF is we really don't have our act together, so to speak. We've got a lot of details and bugs to work out on the plaintiff side, maybe with liens and so forth, finalizing structures, other investment tools, and or setting up formal trusts. And so this QSF is a nice way to be able to discharge one or more defendants in a case, get the money corralled somewhere. You can still structure out of that corral of money. And typically this came out of more of the mass tort arena, but we're seeing more and more now single plaintiff QSF type usages. And then also, QSF usages for plaintiff attorneys to delay recognition of income tax recognition on attorney's fees in personal injury cases. So I think, just in my personal opinion, and we do work in the QSF space, I think we're still kind of emerging as a country on how to best utilize QSFs on a bunch of non-traditional methods, as I just mentioned. And I think at some point, as that practice area continues to evolve, you're going to see the IRS give us more guidance, because I think it's possibly something that could be abused. I know I've had discussions with plaintiff lawyers and other people involved in those setups where they say, well, how long can I defer my attorney fees? Can I defer them forever? The IRS really hasn't said much about that. And I think that just like anything, it's the same reason why I remember when Medicaid was a 3-year look back, because yes, I've been practicing that long. Is it gets abused and they make it a 5-year look back. And some of us remember when Medicaid was discussed to have a 10-year look back a few years ago. So I think QSFs are great when they're used at the appropriate way. And I think it should be just another arsenal you have in your weapons storage to do things for your client or for all the parties involved. Okay. So
Julian, I skipped the slide, so I didn't know if you wanted to quick talk about this slide.
Yeah, sure. Absolutely. This is important stuff. Thanks, Stacy. So settlement plans, right? That's the primary. I started out as an elder law attorney over 20 some years ago and doing a lot of special needs, but now I pretty much do exclusively settlement planning work for plaintiffs. And, so these are all things that come up when you're starting to discuss things with that family. Some of those cases, I have a case right now I'm just finishing up. It's been 4 years that I've been with this family. We finally got to mediation, and I think COVID had a little bit to do with that. But remember, all these things we're talking about on this slide, regarding accepting the money or not, and all these benefits planning, the one thing I would say is that there's never a one size fits all. I don't like whenever people come into the equation and say, well, this person's under 65, they should do a D4A payback trust. Well, maybe they should. Maybe they should do a D4A trust and a third party trust. Maybe they should do something else plus a structured settlement. Maybe they should buy real estate, put it into a preservation trust or something. There's so many things you can be doing here. And now with the ABLE accounts, there's another piecemeal place where you could dump another $15,000 if you wanted to put that into an ABLE account. So I really believe in comprehensive planning for the client and the associated family, because it always affects the family too. It's not just the injured person. And so, we check down through a variety of these things with the benefits planning tab on this slide. And more, we're getting calls about Medicare set-asides. I just got a call this morning from a plaintiff attorney about whether or not he needs to do a liability Medicare set-aside. I would have never got that phone call 5 years ago. So, it's getting on people's radars. And I think it's our job as an organization to continue to bring that out to the plaintiff bar and the defense bar as well, and explain to them that it's not just about structured settlement or a payback trust. There's so many more things here we can do now that we couldn't do even just a few years ago. So thanks for going back to that slide, Stacy, because that's important stuff. All right. So since a lot of people, once again, one of my pet peeves is that people default to saying, well, you're injured, you're getting a settlement, you need a special needs trust. And my answer is always, maybe you do, maybe you don't. And what if you're over age 65? Then what are you going to do? So, just because you're over 65 doesn't mean you don't get injured, right? So we have to talk about that. But here's kind of a neat little flow chart that shows you from top to the bottom how we categorize these things. And this is all stuff that is pretty universal as far as how it's referred to across the United States. But every state is a little different. And so that's once again why it's so important to contact a local attorney who's qualified, who understands the local state rules, the local customs about how to set these trusts up. Pennsylvania has some crazy rules and they have some great rules. Pennsylvania is an extremely generous state when it comes to Medicaid benefits. And so special needs trusts are approved fairly easily in Pennsylvania as long as you don't try to reinvent the wheel. But basically, we're breaking them down into two categories, right? There's the self-settled special needs trust, which many of us have worked with and are familiar with. And those are set up by federal state statutes. And they're pretty easy to do, right? Because you just have to follow the statute. They're set up by, and funded with money owned or accessible to the injured, disabled person, versus the third-party trust, where it's set up by a third party, where maybe you have parents setting up a trust for a disabled child, or a family member setting up a trust for a sibling or something like that. And so, those trusts don't require payback, the third party trusts, at least in Pennsylvania, they don't. And so I think there's other states where that's the same way. What I will say to you is it's interesting, and just to drive another point home about this, I was conversing with a colleague recently on an Ohio case. And in Pennsylvania, if you give money out to a third party, that third party is allowed to set up a third party trust. They don't have a step distribution rule like the IRS says. Ohio has a specific statute, and this is just an example I'm throwing out there for food for thought. Ohio has a specific example that says if you have a trust that's set up as a supplemental needs trust, but any of the funds in that trust were previously owned by the disabled person, that trust is an available resource for Medicaid. And that's interesting because Pennsylvania, for example, does not have that statute. Ohio does. So once again, I live and work close to the Ohio border. So when we get a case and we're not licensed in Ohio, we would ship that over to Ohio Council because it really does vary from state to state. Last thing I'll say about special needs trusts is just as far as like the organization of them goes. You'll see these D4A, D4Cs, and standalone and pooled trusts. Basically, we're talking about the difference between having your own trust document that is set up just for one injured or disabled person versus the pooled, which is basically typically a nonprofit corporate trustee that's running a pool of hundreds, if not thousands, of disabled people who each have a share of that trust. Either way, the goal of this entire page is that whatever assets are owned by these trusts are not countable for any types of government benefits, most importantly, Social Security and Medicaid. So I think that's a pretty good primer on that. This is kind of the last slide for me, I think. So you can take a look at this. I find it a little bit hard to see with my eyes, but it gives you a little breakdown of some more differences between the first party and the third party SNTs. And so I talked a little bit already about who sets it up, and that's where you kind of get the first party and the third party. But typically, you can look through these things, and as you get more down towards the bottom, you get more of the finite things about these trusts. One thing that jumps out at me is the second to the last one is whether or not it's testamentary. And if you're not a lawyer and you don't practice in this area, you might not know what that means. So let's talk about just for a minute the second to the last two, inter vivos and testamentary. So when you're setting up these trusts, remember that you typically would do an inter vivos trust, meaning you draft a document, you sign the document, notarize the document. It's a working live document. You can accept funds right now. A testamentary trust is something that's going to be set up through another instrument like a will. So in your last will and testament, you might say, I have one disabled child, I leave his or her share into this supplemental needs trust for his or her benefit for their lifetime. And that would be your testamentary trust. One thing I caution clients about, at least in Pennsylvania, and this is once again just food for thought depending on what state you're in. In Pennsylvania, like many states, those third-party trusts are a creature of common law and not statute. And so there's always a question of if the common law changes and you have a testamentary trust and it's in a will it really be effective if the law changes before you die? Because the trust technically does not come into being until the death of the person who wrote the will. And so I tell a lot of my clients who are clearly aware that they have, like for example, an adult disabled child, I'll say to them, look, why would you run the risk of the common law changing in our jurisdiction someday for one reason or another? Set up the trust now, a standalone third-party trust. Even if you don't want to fund it, put $10 in it, get it signed and notarized. At least then you have a really good argument that if the law changed, your trust was in existence prior to the case law changing in your jurisdiction. So I know a lot of people do testamentary supplemental needs trusts in their wills. I try not to do them for that reason because I get worried about the law changing.
The exception, Julian, I'd point out is that for spouses, so settlement planners, just be important that if you are doing planning for a spouse, those do have to be testamentary. We can't get around that based on federal law.
That's a great point. Yeah, that's a great point. I was thinking just of the child exception, but no, that's a great point. And I think that's it for me, right? I'm just doing that slide. I think we're going on now. Yeah. So thank you.
So now we're moving on to ABLE accounts. A lot of the organizations that David, Julian, and I are on have advocated for these ABLE accounts whenever they're getting pushed through Congress. Unfortunately, they did not turn out the way that I think advocates wanted them to turn out. But the basic fundamental concept is that we just want to encourage some sort of accumulation of private wealth for people with disabilities so that they can help fund disability-related expenses. So one of the things that were carved out when these got, whenever this passed through Congress, was that your disability actually has to be prior to age 26. And so there's lots of people who call me. I actually just got a guy that called me 2 days ago. and he wanted one of these. However, he did not get his disability determination until his 50s. And so as a result, these are not permissible for him. In order to determine whether or not somebody was disabled, you either have to have received SSI or SSDI prior to that time, or you can file a disability certification. So some of the mental health illnesses, we can sometimes go back and say, well, technically they had it at this point in time. And we've been able to get those passed here in Virginia as valid ABLE accounts. The contributions to these accounts can be made by anybody, but in general, it cannot exceed the total of whatever the gift exclusion amount is for that year. So $15,000 this year. When the Tax Cuts and Jobs Act actually was passed, what they did was they allowed for the earned income of the account owner to actually be contributed to these things as well. So while we're used to saying there's a $15,000 max funding limit, there actually is an ability for a person that's working to contribute more to these accounts. Each state will also set its own aggregate account limit. So here in Virginia, ours is at $300,000, which mirrors just a traditional 529 account. And so understanding state law is going to be important there. It's important to note that if the value of the account exceeds $100,000, then SSI benefits will be suspended by the Social Security Administration, but it will restart as soon as those accounts are back below $100,000. Additionally, the Medicaid benefits should stay in effect. So usually what happens is if you lose your SSI, they're automatically going to turn off Medicaid, kind of depending on what, because a lot of times it's income dependent. But in this situation, because SSI is not actually being terminated, it's just suspended, Medicaid will stay in effect. The other thing is that there is a Medicaid payback. And so I see a lot of people come into my office who say, we want to start funding an ABLE account. And my first question always is why? And it would be, mom and dad, we want to put $15,000 in per year, whatever, start saving. And I say, well, that's subject to a Medicaid payback. If I use a third party S&T, at that point in time, we don't have a Medicaid payback. So I wouldn't recommend you putting a whole bunch of money into an ABLE account. I think in general, I use these for two purposes. The first one is going to be if I do get a small personal injury settlement of less than $15,000 or even a small inheritance of less than $15,000, or I do use them to offset what's called the in-kind support and maintenance role. And so when David was talking about SSI and how that can be reduced, there is a 1/3 reduction whenever like a special needs trust or somebody's just not charging rent. You get it from mom and dad, whatever the case may be, you can lose your SSI by 1/3. And so what I often do is I counsel parents to instead put the shortfall for rent into an ABLE account that's in their name. Anybody can contribute to it. And as a result, it's not money being received from somebody else. And so we can then get the full SSI benefits for an individual. So those are probably the only two times that I really use these type of accounts. Stacey. So one of the big things about ABLE accounts is that they have to be for disability related expenses. The Treasury is supposed to be defining kind of what all those are. What I'm finding out here, because Virginia has what's called ABLE Now, is that they're pretty much saying anything is a disability related expense at this point in time. So it's pretty wide open. And so you can see kind of a list of things that are on there and available for ABLE. The timing of some of this stuff, really good counseling when you're talking about ABLE accounts comes into effect, because essentially if you pull the money out and it's supposed to be for a certain expense, such as housing, but it's retained in the individual's bank account for the following month, that could trigger an impact on benefits. And so understanding the interplay of ABLE accounts with those public benefits, timing of distributions, and the impact that they're going to have really does become important. In the event that there are too many contributions to the ABLE account in a given year, or if a withdrawal is made for something that was not a disability related expense, there are penalties associated with that. So too many contributions, they're going to actually say that it invalidated the ABLE account. And if the withdrawal was for something other than a disability related expense, which we haven't fully defined yet, then it will be subject to regular income tax and a 10% penalty. And that income tax is just based on the growth within the account. Under the Tax Cuts and Jobs Act, we also have the rollover from an ABLE account to from a traditional education 529 account now as well. This was something that the Treasury refused to opine on, so we had to wait until we got law on it. All right, Stacey. All right, so now you get to traditional Medicaid spend downs. So all the elder law attorneys, this is like kind of our normal course of business here. It is important to note state rules vary. So Virginia is a 209B state, and David and I were talking prior to coming on. What that means is I have a lot more options and stuff that some of the other states don't have. And so some of the options that we can look at when we're looking at spend downs are savings bonds. There are some sort of annuities that we can do. Now, the rules of these things are very important. And so just a regular structured settlement is not going to necessarily be an available option here. There is going to have to be a Medicaid payback on these annuities as well. Sometimes there's some exceptions to that, but understanding that annuities are an option, we primarily use those for married couples. Prepaying burials, purchasing of goods and services, or tangible personal property. We can also make transfers to a spouse or a disabled child. And so I usually tell my clients that if I have a married couple, one of them needs to get on long-term care Medicaid, I can normally protect about 100% of their money based on the options that are available here in Virginia. And so I often see, where the family has already spent 50% of the assets or whatever, and they're finally getting to me. It's, the sooner we can get them on, the sooner we can start protecting assets. Once the spouse is actually on Medicaid, they no longer care what the spouse that's at home is doing with their money. So they could literally hit the lottery the day after their spouse got approved for Medicaid, and they get to keep that money. They don't have to share it with their spouse or spend down any further. There are also some exceptions for caretaker children. So in Virginia, we can actually transfer the house to a caretaker child, kind of as compensation for keeping their parent inside the home for a period of time. And then you do have certain promissory notes that we can use as well. Now, that's all an asset spend down strategy. There are certain states where you have income limits. And so in Virginia, we can go what's called a month-to-month spend down for in-home benefits. As long as the nursing home private pay rate is higher than the person's income, we don't have to worry about anything there. However, in Ohio, where David is, they have these funny little Miller trusts to spend down income. And so he can explain those a little bit better than what I can.
Yeah, the Miller trusts, or what are called QITs, qualified income trusts. In Ohio, we have what's called a special income limit. If your income is over 3 times the SSI amount, which would be what, 794 times 3 is about. If your income is more than $2,382 a month gross, then you have to put that excess income into this income trust, this Miller trust or this qualified income trust. And what is sort of baffling about it is once the money's in the trust, then you take it out of the trust to give to the nursing home. And so there's really no point to it at all. There are some other requirements based in federal law that it has to have a Medicaid payback, but we're not really seeing any money left in these because the excess money goes in, you're able to achieve income eligibility. The money in the qualified income trust or the Miller trust then pays the nursing home for the patient liability, the amount that the resident is required to spend on their own behalf. So it's a relatively new rule for us in Ohio. August of 2016, we converted from a state like Shannon's, and so now we have to use these, and it's really just a pain more than anything. But if you don't do it, if you're not paying attention, I mean, a big problem is in Ohio, you can apply for Medicaid in January, and you may not get a determination from the county until May, particularly during this pandemic. And if you applied and you didn't know that you needed to set up a qualified income trust or Miller trust and administer it every month, they're going to come back and say you're ineligible for those 3, 4, 5 months. And at $10,000 a month, that's a big mistake to make.
Next slide, Stacey. All right, so now we get to Medicare set-asides, which is probably all of our favorite thing. And essentially there's 2 categories. We kind of have some bright line rules on the workers' compensation side, and we can get approvals. So we look at the Patel memo, and basically what we have to determine is whether or not there's a reasonable expectation of Medicare within 30 months of the settlement date, and that the settlement is more than $250,000. So what are we looking at here is the individual 62 years of age and 62 and a half years old, because then they're going to be eligible for Medicare coming up. are they in the process or intending to file or appeal or otherwise refiling for SSDI? I was just working with a personal injury attorney, and I thought everything was in the clear. He had said, no, she was denied Medicare. She doesn't, whatever, she's just going to use this money. And then he said, but in a year from now, she's going to refile for SSDI. And I was like, well, you may want to just consider looking at this workers' comp set aside. And then you have whether or not there are some either Lou Gehrig's disease or end-stage renal disease, because those will accelerate the entitlement to Medicare when you're approved for SSDI. And then if you're already on Medicare, then basically if the settlement's in excess of $25,000, then it should be reviewed by CMS to determine whether or not you need the Medicare set aside. Now, we do not yet have rules for the third-party liability side of things. And so as a result, we do see a lot of trial attorneys basically refusing to fund Medicare set-asides until such time that we do have rules. Some of my contacts are inside working with CMS to get these rules hashed out. But until we have those rules, essentially, I think what most of us do is we rely on the Patel memo, because that's really the only formal guidance that we have for anything at this point in time. It's also important that in the event that somebody is receiving means-tested benefits, then we need to put this Medicare set-aside as a sub-trust to a special needs trust so that it's kind of encapsulated and not looked at for. So we do have that little issue. Next slide. All right, now we move to the Affordable Care Act. So something that happens quite a bit is we get calls from personal injury attorneys or settlement planners, and they say, well, somebody's on Medicaid. All right, well, what kind of Medicaid are they looking at? What's their income source? These are the questions that I normally have, because not every Medicaid program is going to necessarily be impacted by the settlement. Also, there are times where if it's just classic Medicaid and we are just trying to make sure they have some basic health insurance, there's times where we say, let's lose it. If we're not on a waiver program here in Virginia, it may make better sense to look at private health insurance or something under the Affordable Care Act. And so in order to qualify under the Affordable Care Act exchange programs, there is an income test, which will be on the next slide. And then basically you have to not have access to affordable coverage via your employer, and the standards for that are on the slide. And you can't be eligible for Medicare, Medicaid, or CHIP. You have to be a US citizen or a legal resident, and if you're married, you must file a joint tax return. In the event that you do qualify or you're eligible for ACA coverage, then there are subsidies in place that can range anywhere from $12,760 to $51,040 for an individual, and then for a family of 4 that's increased. So there is help to pay for these things, which will help reduce the cost overall for a family. On the next slide, this is where we get our income limits. And so if you're in a state that doesn't have expanded Medicaid, you're looking at anywhere between 100% to 400% of the poverty level. And if you fall within that, then you meet the income test. If you have Medicaid expansion in the state you're working in, so Virginia does have expanded Medicaid, then it's actually 138% to 400%, because below 138%, you get expanded Medicaid coverage in Virginia. And it's important to know too, when you're looking at ACA, they're not looking at your bottom line income. What they're looking at is the modified adjusted gross income. So they will take whatever the household's adjusted gross income is and then add certain things in. So they're going to include foreign income that was deducted out, the non-taxable Social Security benefits. So this isn't going to include SSI, but it will include Tier 1 railroad retirement. And then any tax exempt interest will also be added back into the equation. You can adjust, so if you're applying for something through the exchange, you can actually adjust your income based on expected changes. So if you know that somebody's lost their job, for instance, then you would be able to reduce down that income. So now we get into the other fun issues that we see, and I think that these are things that I'm starting to see more and more just over the course of probably even the last year. So my favorite one right now is crowdfunding. And so anytime we're dealing with mass, catastrophic injury or some sad event, friends and family are now setting up GoFundMe accounts. The problem is that depending on how these crowdfunding accounts are set up, they could be available resources for the injured person. And so meeting with an elder law attorney before that happens is ideal, but oftentimes we have to clean it up on the back end. And I have had, there's a local attorney here, he's absolutely brilliant, but he told his client for 2 years that the money in his GoFundMe account was actually not available to him. So then they come to me, I need to work on a Medicaid spend down, and now I'm the evil person because they can't have this money just sitting around anymore. That's kind of one of the interesting things that technology has brought out that we're now dealing with on the back end of these settlements. So asking about, do you have any GoFundMe accounts or anything like that set up becomes important in the planning. Getting court approval. So if you, in most states, if you're incapacitated or if you're a minor child, we need court approval. What happens is we get brought in sometimes really late in the game. And I have one right now out of Missouri where the court has already approved the settlement. It was directed to go into a conservatorship that had not been set up. And now we got to get the conservatorship set up just so that we can now get the trust funded. So there's some extra steps in there, and it's extra cost to the plaintiff, unfortunately, for us to have to go through these extra little hurdles to get this done. So one of the things is that when we're going in to get when we're getting approval of the settlement itself, we usually want the payment directed to the trust. So that way, number one, if it's a special needs trust, it hasn't hit any other sort of account where it could be potentially available. But then number two, it just kind of makes it a little bit easier to get the money where it needs to go. We also have constructive receipt issues. So basically, just because the attorney has the money sitting in a trust account doesn't mean that it's protected. What I normally tell my personal injury attorneys is the second that you can look at that money and determine the amount that's available to the plaintiff, it's now available to them for public benefits. And so I do have attorneys, once again, we get involved sometimes pretty late in the game, that have had money sitting in a trust account for 6 months. They've already paid off the liens and they just weren't able to figure out what they needed to do with it. And so in those cases, we've been over-resourced for 6 months, unfortunately, and we have to report that to both Social Security and Medicaid. And then the other thing that...
Sorry, can I interrupt you? Just, we're kind of running out of time. I know you have one more topic on your other issues, but I figure people can contact you directly. I want to just get to some couple of questions real quick because it is 1 o'clock. This has been so interesting. I think the takeaway for me is please make sure you contact an expert in that state, a trust attorney, elder law attorney. They know their stuff, as we witnessed today with our panelists. But real quick, is a long-term disease that is not currently disabling, such as HIV, eligible for an SMT?
The question is whether or not they can work. So technically, you don't have a Social Security defined disability until such time you can't meet the work requirement of the income, which is what, like 1310 or something right now. And so if they're still working, they're not technically disabled, so they technically wouldn't be eligible for an SNT or really need one. You know, as long as they're determined to be disabled prior to age 65, we can always trigger on a special needs trust later. But if they don't need it at that point in time, then it would. That's where the more flexible trust options that we look at play.
Great. Can a structured settlement qualify as a DRA compliant annuity?
Julian, that's your favorite, isn't it?
Yeah, because I see so many people get those and then they find, they see what happens later and they go, what happened? I thought this was going to be fine. You can make a structured settlement DRA compliant, but as Shannon had mentioned earlier, it's got to meet all the tests. So you can't have any irregular or lump sum payments throughout the term of the annuity, and it has to name the state as a payback for Medicaid benefits paid out. So those are just two things that are really different than a typical structure, but you can amend it and they have to give you the right to fix the annuity if you do it wrong the first time.
Great. Maybe David, you can answer this with a stable account. For ABLE accounts, is there any risk for the fiduciary if they fund an ABLE and the person doesn't use it towards qualified disability expenses?
I don't think so. As long as the fiduciary is operating within their proper scope and not doing anything wrong. And if it's a guardian, then the individual shouldn't have access really to that stable account anyway. bottom line, if we have a competent adult disabled beneficiary of a stable account, once the money's in that account, it's really their money. It's just not countable for SSI and for Medicaid. And that's part of the reason why they become very useful to get around the in-kind support maintenance rules, is because it is considered to be their money, no matter where it came from.
Great. And one last question. We have a client now debating an S&T versus a preservation trust. If an S&T funds an ABLE account, could the ABLE account buy a fishing boat for the injured person? Or without an ABLE account, could an S&T buy the injured person a fishing boat without disqualifying them for means-tested benefits?
Titling is going to be important.
What's that?
Well, titling is going to be important on that, because in Virginia, if it has a license plate attached to it, then it's considered an automobile or a vehicle. And so as a result, you can only have one vehicle. So the disabled person themselves actually could not have both an automobile plus the boat. So little nuances like that sometimes go into play as well.
But it could be
Again, why? Oh, go ahead, Julian.
Can I add that if you just don't buy a trailer in Pennsylvania for your boat, you won't have a license plate. And so you can just put the boat in the water and leave it in the water. There are ways to do that. I've bought quads for kids and with disabilities and things for recreational therapy. And so there's ways to get that done in many cases.
Well, I know we have some other questions, so Shannon, David, Julian, I will send them to you, and hopefully we can get them answered. I do unfortunately have to go on to another presentation. So again, Shannon, David, Julian, I thank you. I think we could have done another hour on this presentation. I know your time is valuable, so thank you from SSP.
Thank you.
Thank you.